Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Today, I want to talk about circumstantial evidence and where you can find circumstantial evidence. As you know, direct evidence is almost always not present for a plaintiff to prove their case. Of course, under McDonnell Douglas, once the plaintiff files a lawsuit, let's say, for example, discrimination and retaliation, the defendant then has to return with a non-discriminatory reason as to why the company terminated the plaintiff or the adverse action that the company took against the plaintiff is for non-discriminatory reasons. And once the defendant has established that, then of course the plaintiff must come back and show the court that the reason or the articulated reason by the defendant for the termination of the plaintiff or the adverse action taken against the plaintiff, it really was not the true reason. It was really an articulation that was a cover-up for the defendant's discriminatory animus and retaliation. That's called pretext. And pretext, for the most part, is produced or shown through circumstantial evidence. And I want to talk about one place where a lot of plaintiffs don't look for circumstantial evidence. So let's get started. The one place litigants don't look for circumstantial evidence is the employee's execution of the disciplinary policies relative to plaintiff's termination. In other words, the employer should follow the steps outlined in its disciplinary policies before terminating the employee. And even though the steps were taken by the employer, the question is, were they genuine? Or were they motivated by discriminatory animus, and in this case, retaliation? What is inferred by the action of the employer is critical. Let me show you what I mean by illustration. For example, in step 1, plaintiff receives counseling and a verbal warning. Is this the plaintiff's first warning? Did the warning occur after plaintiff complained of discrimination? And after plaintiff's warning, plaintiff complains that he believes that he is being retaliated against because he complained of discrimination. Plaintiff receives a written warning for an incident he states he is not responsible for, or the incident did not occur. He even tells his superior that he believes that this is retaliation, and he supports this with information his employers would change his duties, change his assignments, alter his assignments. Each time superiors would write him up or counsel him, plaintiff would always provide information contradicting the merits of the accusations or charges against him. The company progresses its disciplinary action against the plaintiff based on a charge that he denied and for which he writes a rebuttal to, as he did in the past, and he is now issued a suspension and final written warning. Like all other times, plaintiff wrote a rebuttal and provided evidence to support his rebuttal. And of course, in these processes, there is an investigation. And upon completion of the company's investigation, recommendation is made. And in this case, the company recommended to terminate the plaintiff. These progressive disciplinary policies usually allow for an appeal, or they should allow for an appeal. But here's the question you should ask. Would a reasonable jury believe that the company's articulated reason for terminating this plaintiff, was it genuine? Or was it a cover-up for discrimination and retaliation? Pretext evidence creates powerful inferences, to name a few, such as genuineness, and we talked about that, inconsistencies, the suspiciousness of the timing of the adverse action, ambiguous behavior towards the member of the protected group. You must be proactive. And that's the takeaway here. Being proactive, not after the plaintiff has been terminated, but be proactive at the beginning of your employment. Here are some takeaways. Read and understand your company's workplace policies. When the plaintiff gets hired, he or she should study and know the company's workplace policies. At all times, know your company's expectations of you and where you stand, for example, how you are progressing. Immediately get a written copy of any disciplinary action that may be taken against you with the identification of the policy you purportedly violated and an explanation on how you purportedly violated the policy. If documents are involved, ask for a copy of them. If you disagree with the write-up or adverse action taken against you, rebut it in writing. A lawsuit is doable. The plaintiff can win on circumstantial evidence, but you got to work for it. Okay? I hope this has been helpful to you. I'm Advocate Lucinda. Be empowered.